कहाँ देखिए क्या
देखिएगा ये वीपी लिंक से जो है ना सर पार्सल नंबर
आपने कैंसिल करने का पावर कहाँ है? कैंसिल टर्मिनेशन
सीनियर डीसीएम को ही पावर है, सीट ने उसने अप्रूव ले सीनियर डीसीएम ने ये
सीट ने पूरा लिख के ये अप्रूव हुआ सर। ये देखिए सीनियर डीसीएम अप्रूव किया, इसीएम नोट दिया, ऑथराइजेशन लिया इसीएम इसमें। ये 3 सेट है सर, 3 सेट के दीजिए दीजिए।
कौन सा पेज बोलिए?
नोट दिया, ऑथराइजेशन लिया इसीएम इसमें। ये 3 सेट है, 3 सेट के दीजिए दीजिए।
What I was mirrored just now I was submitting this complaint that he was authorized to
नोट दिया, ऑथराइजेशन लिया इसीएम
I am extremely sorry because that complaint
3 सेट के दीजिए दीजिए।
I did not get what I was just now I was submitting this complaint that he was authorized to I am sorry, extremely sorry. I apologize for this that's why I pray for your sorry because this time at least
3 सेट के दीजिए दीजिए।
no I did that what I was just now I was submitting so that he was authorized to I am sorry, extremely sorry. I extremely sorry. I apologize that's why I pray for your sorry because this time
3 सेट के दीजिए
no I did that what I was just now I was submitting but here now that he was authorized to I am sorry, extremely sorry. I apologize sorry. That's why I pray for your sorry because this time
3 सेट के दीजिए दीजिए।
I did that what I was just now but here now that he was authorized to I am sorry, extremely. So that point was also raised by your lordships. If your lordships permit within 1 day I will form an affidavit and come back.
That was an opportunity given to when you find trial court. Not say anything.
No, Milord.
Rather, your statement was too weak.
No, Milord, but here, Milord, here categorical statement is that, Milord, I have read out, Milord, before your lordships, Milord.
No.
He authorized, Milord, to sign.
Not within.
He was the authorized.
Case is made out in a trial court. The moment the court made certain observations, the trial court in the judgment and say that this is lacking. On facts before the appellate court in the stay application, something more is coming up.
It's true.
The court, suppose the appellate court takes into consideration and make further findings. In the second appellate court, in the stay application, something more facts will come.
No, this is fast appellate.
Okay.
We are subject to correction.
Stay application.
We are subject to
When
correction.
the High Court also makes certain observations, taking into account those, before the Supreme Court, something more will come. That this is what is there. Is this a fundamental principle of this country to decide the cases in an adversarial system of adjudication? When you get the first opportunity before the first court, the court of first instance, you did not say anything. Order 41, Rule 27 was introduced for very limited purposes. Because they say that you will not be permitted to take any document into consideration. The appellate court should not. And there is a ground which is given that on these grounds there must be a pleading. You have been harping. You are a veteran in the profession.
No.
You have said something in your stay application and wanted the court to take into account. Is it a proper way when an appellate court is really considering whether the finding or the judgment of the trial court is correct or not?
Milord,
Judgment is based on the pleadings made before the trial court.
Milord, subject to correction, Milord. What I mean, subject to your lordship's consideration, Milord. Appointments were there, Milord, that it can have the power in this way, Milord. But categorical, that is, Milord, in an
Senior was there, we have made certain observations on this.
explanation, Milord, that clarificatory explanation in the, Milord, in the matter stay application, Milord, definitely, Milord, making an observation.
When I will start interacting, it will augment more adjournments to come.
No, my lord.
So I was keeping.
I am submitting, my lord. My lord, not for any.
Times you have repeated the same thing.
No, my lord.
Suspension, there is no provision provided.
How can they suspend within 24 hours? There is nothing. 5 times you repeat it.
Lord,
It really, it make the railway to suffer because of this 5 times.
my lord, I am sorry, my lord.
Counting,
No, my lord, that's my bad habit, my lord. If your lordship says.
yes,
But-
sir, we have taken note of that fact. What we have
Yes, yes.
Let us see.
Now, my lord, what I am submitting, my lord, that it is not a new document that we have not brought into your lordship's notice, my lord. That document was already there, authorizing to do that, my lord. That document, my lord, is a fast appellate court, my lord.
It's not there.
That is the
If
first-
no, we'll go by an amendment. What does amendment?
My lord, that amendment,
So by that.
my lord, if I may, I beg to be excused me to submit in this way, my lord, subject to
was
lordship consider, my lord.
filed by you in 2022.
Yes.
You did not care.
And-
You did not care to file an application. When the matter came up for final disposal, now you think that you file an application. When the matter came
Why
up
you
for
did
final
not annex?
disposal,
Why you
now
did
you
not
think
file
that
an
you
My lord,
application
my
takes
lord,
time and
internal communication, I should not make. My
Why
lord,
that
no,
I was not in case somebody.
no, my lord, no, my lord, I am sorry. My lord, this is, my lord.
If you have inherited the
But-
asset, you must inherit the liability as well.
Yes, my lord. But we kindly consider, my lord, under what circumstances within 24
Charging in
hours I
quickly
had
to
to, my
board
lord,
his
make it
fastest
ready.
delivery.
Such a voluminous period, even when the
Switching
vacation was
game's
going on.
momentum.
At the last
Pacing
end of the
innings
day, which was
forward,
given, my
the
lord, I asked for
undisputed
documents, my lord, I
impact
my lord,
player.
subject to your lordship's
It's
consideration,
the
your lordship's notice, my
champion
lord.
of champions,
When
the feature-loaded Nexon, India's #1 SUV for 3 years in a row. Price starts at 7.99 lakhs.
yes, the document was
It's a
there. My lord,
move away from
I would say it's
an
a
old
ambiguous
school-
statement which was made in paragraph 70.
yes, my that document was repeatedly asked for, my lord, the person who was instructing me, my lord.
If they do not provide me-
Unfortunately, my lord,
if they do not provide me,
unfortunately, my lord, but my lord, kindly consider this thing, my lord. It is not a case that for the purpose of
Necessarily, I cannot argue as a lawyer.
No, my lord. I kindly also
Argument,
no, my lord.
one point you have left, you have not argued about this submission and the blacklisting.
Yes, my lord. Lord.
That argument you have not advanced. He has cited 3 judgments on blacklisting.
Yes, my lord. My lord, with great respect to my learned friend and to your lordships also, my lord, that blacklisted, my lord, word was never used or no apartment was there even, my lord. If your lordship can never.
I know. this
Yes, my lord.
argument will
Yes,
come
yes,
from-
my lord.
I know it.
May I submit, my lord?
No. The recent judgment of the Supreme Court has said that what is the meaning of a blacklist? Blacklisting may not be used, but the consequence of blacklisting is provided, and it is elaborated here. I'm just reading for your turn.
My lord, may I
May I read for your turn?
yes, yes. इसीलिए आपको जो कितना टाइम इतना बोले तो ऑपरेशन बोलेंगे बात नहीं बोलेंगे तो पहले ओपिनियन
Yes, may I read for you? It is a common case of the parties that the blacklisting has to be preceded by a show cause notice. Law in this regard is firmly grounded and does not even demand much amplification. The necessity of compliance with the principle of natural justice by giving an opportunity to the person against whom the action of blacklisting is sought to be taken has a valid and solid rationale behind. With blacklisting, many civil and or civil consequences follow. It is described as a civil death of a person who is foisted with the order of blacklisting. Such an order is a stigmatic in nature
yes, yes,
and debars
yes, yes,
such a person from participating
yes.
in the government tenders, which means precluding him from award of government contracts. This
I
is
have-
the
I have-
purpose
I-
of blacklisting.
Yes.
Then the court has
Dividing.
further
Then dividing, my
said
lord.
that what is the meaning of a blacklisting?
Now, look, at the same time,
Blacklisting, I'm reading this paragraph. Blacklisting has the effect of preventing, has an effect of preventing a person from privilege and advantage of entering into lawful relationship with the government for the purpose of gains. The fact that a disability is created by an order of blacklisting indicates that the relevant authority is to have an objective satisfaction. Fundamentals of fair play require that the person concerned should be given an opportunity to present his case before he is put on a blacklist. Then, insofar as the contention that there is no requirement specifically of giving any notice is concerned, which you will argue, the respondent is right, but it is an implied principle of rule of law that any order having a civil consequences should be passed only after following the principle of natural justice. It has been realized that blacklisting any person in respect of a business ventures has civil consequences for the future business of the person
I'll go.
concerned in any event.
I will satisfy yours.
Even if the rule do not express so, it is an elementary principle of natural justice that the party is affected by an order. You say that you have not used the word blacklisting.
No,
You have debarred him from
your lordship,
any tender for 2 years in future.
kindly come back, my lord. I will satisfy your lordship. I will satisfy your lordship.
Elixir of the concept blacklist.
My lord, with my limited knowledge, I will try to convince your lordship. Kindly, your lordship, come back, my lord. I have brought the my lord. My lord, what is the difference between the blacklisting and also, my lord, that is debarring, my lord? What is it? Like, my lord, my lord, your lordship will be, my lord, formulate the judgment. Yes. No, my lord. But here, my lord, but there was a case, there is a different case, my lord, blacklisting. It is not a case of blacklisting. It is debarring. My lord, kindly have a look at.
That the language which you have used.
No, that language I am on grammatical. My lord, I am on a grammatical. My lord, kindly have a look at the grammatical meanings. Debarring and my lord, like my lord, dismissal and removal. When a removal is there, my lord, there is a different case. Blacklisting. It is not a case of blacklisting. It is debarring. Yes, my lord. That's why, my lord. Your lordship.
Oh, you are coming with the definition of
Definition, my lord. Language. What is the meaning of debarring and blacklisting? My lord, I am our case is that it is we have grammatical meaning. Debarring and debarred. If it is dismissal and consider will make when removal is there, my lord. So for blacklisting is considered nowhere he has blacklisting or make any debarring. Yes, my lord. That's why, my lord. So learned trial judge, my lord, while considering the, my lord, definition, my lord. Language. What is the meaning of debarring and blacklisting? My lord, our case is that it is we have grammatical meaning. Debarred and the judgment will make the removal is there. So for blacklisting is considered nowhere he has blacklisting or make any debarring. There is no bar, my lord, in blacklisting. There is a bar in the future. Definition, my lord. What is the meaning of debarring and blacklisting? Our case is that it is a case of grammatical meaning. Debarring and the judgment will make the removal is there. So for blacklisting is considered nowhere he has blacklisting or make any debarring. There is no bar, my lord, definition, what is the meaning of debarring and blacklisting? Our case is that it is a case of grammatical meaning. Debarring and the judgment will make the removal is there. Nowhere he has blacklisting or make any debarring. There is no bar, my lord, but in our case, my lord, totally different, my lord. Factual matrix of that case and this.
That was saying the application. That is saying that you never use the word blacklisting.
There is
what expression which you have used, whether it is akin to a blacklisting or it is something which is new.
Yes.
They leave it to us to decide.
Let's make some submissions on that point, my lord, to convince your lordship, my lord. There difference has been made over there. And our case is that it is not a case that after 2 years he cannot participate in that. Lord, I can, my lord, on instruction I am submitting, my lord. Our case is that, my lord, for 2 years. If it is, my lord, so far that party is concerned, if your lordship thinks, my lord, it is a submission from the bar, my lord, to assist your lordship, my lord. because we, the lawyers, the creatures of the mirror, statute mirror, we have to make submission not only to oppose but to assist the honorable court mirror. But if it is found that
The second one is more important.
yeah, that I know mirror. Now mirror, the case is mirror. Your lordship has to mirror, consider mirror all aspects of the matter.
I have argued, we invited you, omitted to argue this point, we invited you to argue. We consider that. Any conclusion?
May-
The judge
inspection. Just short points, my lord, by Friday, my lord. Just, my lord, because your
That your point will not be taken. I assure you that every point, every bit of your argument.
I know, my lord, I argued in the space maybe that bench, my lord, super. Sure. The only thing, my lord, what I am submitting, my lord, is, my lord, that somebody has intervened for 2 years. He has been, my lord, carrying on. Yes, my lord, that. A super, my lord, food picture and, my lord, other things, my lord, two things, my lord, that departing, my lord. Kindly consider that aspect, my lord.
Consider that.
Fine. This is, my lord, that somebody has intervened for 2 years. He has been, my lord, carrying on. Yes, my lord, that.
Item number 4. Lord, item 4 and 5, Lord, were heard together. Lord, my item is 43. I have challenged, Lord, the self-same order, Lord, which is, Lord, the subject matter of, Lord, 4 and 5. Lord, with the leave to appeal, Lord, I appear on behalf of the successful candidates. Our apprehension, Lord, is that in the event, Lord, a committee is constituted.
Consider that.
Lord, yes, Lord, kindly, Lord, hears, Lord.
Everybody is there.
I'm grateful. Yes, Lord, I shall, Lord, argue, Lord, on, Lord, the question of law, Lord, as to whether it could be done or not.
But it was almost not decided that should pass an order that the Bishop Bharati, to whom the Honorable Court was pleased to send, there was one representation from the primary board.
And
That is all.
Kindly consider whatever points I have raised. I am on merit one. That there cannot be any third independent expert. There cannot be any third independent expert appointed by the court in the facts. That's our case is that. Because thrice the experts have been appointed, twice by the court, and then again. Then there will not be an end to it.
Lord, on that, Lord, I have, Lord, one submission. Lord, that the right to object, it ceases on the last date inviting disputes. Lord, there are no rules, Lord, which provide for, Lord, inviting objections, Lord, or disputes with regard to key answers. Yet, Lord, in the advertisement, and I would say by way of a generosity, the board invited so. But once a date is fixed, and, Lord, the key answers, Lord, are published, Lord, those who have been assessed in terms of those key answers, Lord, their right to be assessed in terms of the key answers, so arrived at upon considering objections, that crystallizes, Lord, their, Lord, right cannot be, Lord, altered. If my Lord is today, Lord, in thinking, Lord, I do not know, Lord, if my Lord is thinking of constituting a committee, which would, Lord, maybe come up with, Lord, suggestions, Lord, in their wisdom to alter the key answers, then, Lord, that is made applicable, Lord, in respect of all the examinees, then, Lord, it is likely that those, Lord, who have qualified, like, Lord, the appellate before my Lord, their status may get altered. So, Lord,
A question which is there and you have attempted,
my Lord,
appears that the answer key which is given by the authority is not a correct answer. Now look at the plight of the other aspirants who have correctly answered.
my Lord,
Will that right go? Fairness, the fairness is the hallmark of process.
my Lord,
If it appears that the answers which they have uploaded is not a correct answer, then this person should not be benefited by a wrong answer. That deprive the other large number of candidates who have correctly answered that. This is the main issue. We cannot shut our eyes to it.
Lord,
Only because your name appears in the panel as a successful candidate.
Lord, I would address my Lord on that. Lord, I am covered, my Lord, by at least one Supreme Court judgment.
The Supreme Court judgment
My Lord.
each way.
Yes.
What we perceive is that whatever they have come, we will consider this aspect because we find that The first thing is the fairness, transparency, and everything has to be considered. If anything which is absolutely wrong, then in that event, you will not permit anybody.
Lord, this will not right to object. Lord, this right to object, Lord, this will not was
Not a question of right to object. It is wrong to be accepted as correct.
Lord, this will not the question of Lord.
Wrong
I'm sorry.
to be accepted as correct.
Lord, the domain Lord of red court. I'm sorry.
This is what is there.
Lord, the domain Lord of the red.
Lordship has a please to Lord refer it.
Wanted to have domain.
That will not.
The aspect.
Well, we have no names, Lord. Any university Lordship Lord decides to.
No university. They will constitute. We will keep whatever.
Lordship has a please to Lord refer it.
Wanted to have
Yes, Lordship will do that. We have no suggestion. We have no names, Lord. We have no university Lordship Lord decides to. Yes.
No university. We will constitute.
Yes, no problem. Lordship has no problem to that. Refer it. Yes, Lordship will do that. We have no suggestion. We have no names, Lord. Questions. We have no university Lordship Lord decides to. Yes. We have specified the questions, Lord. The concession will yes, no problem. Why we have no problem to that. Therefore, this yes, Lordship will do that. We have no suggestion. We have no names, Lord. Questions. We have no university Lordship Lord.
Common question.
So that if he wants to specify the questions, Lord, the concession will be a list of the questions which we feel is not correct.
And the material.
The more may
And
come.
supporting materials.
More will come, my lord.
More
Once
will come.
upon a
This
time,
is
like I
endless
said,
process.
All 150 should be sent.
That it,
No, no.
Kindly see the order. No, won't say. I have
the order doesn't say so. Order doesn't say so.
I am showing that immediate. Order says so.
Not kindly confined.
The order, sir. We are
That's another aspect. Not on
The court had asked us to be like,
your lordship can do everything, but my lord, the facts
do
just
everything. I think the principles of law. We can't do everything.
my lord, just facts. The facts and circumstances.
well, I can just, Mr. Sanyal is definitely instructed that we've already submitted the list of questions which we really questioned about the justify the key answer. We have given to the board. Let the board refer those questions to the expert appointed by the court. How the board will not feel scared
That's
of it?
my lord, kindly deal with my submissions, but can it be done, my lord, in this situation? That's your lordship do that.
As we say one line, if you want that one line will be elaborated with the tracking of judgment.
Well, otherwise, they could not have my lord, come up with the appeal.
One line will be multiplied or supported by many judgments. Fairness, transparency is a hallmark of
My lord, by publishing key answers, we complied with the fairness and transparency.
what is a very good thing.
Then we have done it.
And if the objections have come, and if it appears that whatever,
আচ্ছা তোমাদের কাছে লিস্ট অফ কোশ্চেন আছে হ্যাঁ
And compilation করে there is also material why it's wrong.
but difficulty now the correctness thereof.
My lord, that,
What is not an expert of the
my lord, that's my point. The learned single judge has not come.
আরে
ওরা সেটাই দিচ্ছে না।
কত বলছি জমা দিয়ে না
substitute.
But court can go into the correctness of the order appeal court.
Definitely not.
But kindly do that, because otherwise they could not have come up with the appeal.
The private way of doing this is not perfect, but the court cannot. Private court, if you find that there is a because if we want to bring a fairness in all its respect,
এটাই দেখুন বুঝতেই পারছি।
এটা কে সৈকত ব্যানার্জি
Yes, Lord, in the name of fairness, my Lord, kindly see, Lord, this cannot be not stretched indefinitely. Lord, there was a date. Lord,
this is the
There are-
list which was sent to the board. Board had accepted through Mr. Shoykot Banerjee, the advocate.
This is in terms of the question,
Yes,
common
the
question
question-
they have.
therefore-
This is not in the writ petition.
No, that's the direction of the court, the honorable court, কোনটা? এটা
By
by-
session, এটা
দুটো আলাদা আলাদা
হ্যাঁ, দুটো।
Must have taken 5 questions. In other writ petition, somebody has taken more. He wanted to have a collective one.
Lord, this is the questions and the supporting materials. We have given that. No, the questions are there.
small list.
I'll question.
It's 7.
There are 19 questions. 19 questions.
তোমার কটা কোয়েশ্চেন আরে কটা কোয়েশ্চেন কটা কোয়েশ্চেন 24 তোমার
So it was 19 in the learned single judges order. Now it has become 24.
there are two matters in one matter
I trust you in this job.
I give leadership.
Consider all those writ petitions which are done. Find out that how many questions. Beyond that,
No, that's the list. That's the list.
is, as he says, is restricted to all 19 only.
Yes, 20 in one matter, 22, another matter 27.
The first time we will not
Nothing. What we have also had given Milord total question in one matter, Milord 22 questions, in another matter 27, 24. This is all.
Total 24 questions in respect of 2022. This is the sir, এটা total 20. This is the list. This is the
Milord, এই বাঞ্ছকার
এটা 2022 এর।
এটা খুলে দিতে হয় লিস্ট ওখান থেকে লিস্টটা বার করে দাও না দর্শককে দিয়ে দিই।
এই ওখানে দেখ ওটা দিয়ে
তাহলে
this is the list of questions we allow.
ওটা বার করে দাও ওটা বার করে দাও
This one. এটা
that list is not there.
just this one.
This first page is a judgment.
যারা ছেড়ে দাও এই
Lord,
এটা দেখতে
My lord, these questions, my lord, if they are not in common, then the number would, my lord, spiral up to maybe more than 24. If the questions are not,
24.
no, my lord, kindly see, my lord, in one it is 19, other it is 17. No, I say all may not be common, my lord, that is
86 questions you have included.
number
কি বলছো লিস্ট
Four different.
সবাই মিলে তোমরা একসঙ্গে কথা বলতে মুশকিল কোর্ট কি চাইছে সেটা বোঝো
I want the list of that 24.
আমাকে একটু দিন আমি দিয়ে যাচ্ছি স্যার আমাকে দিন
প্রথম থেকে তো কোর্ট যেতে চাইছেন তোমরা নিজেদের মধ্যে মারামারি করছো কেন
starting from page 50 মিলার সবাই মিলে
আমি জানি না এভরিবডি স্পিক্স লেটস স্পিক
স্যার আমি বলি যেটা আপনাকে আমি দিলাম সৈকত ব্যানার্জি স্যারের রিসিভ ওটা হচ্ছে 2017 এর অল কোশ্চেন আর যেটা বিক্রম
কেন যে
যেটা 2022 এর অল কোশ্চেন
ওখানে কি লিস্টটা বলা আছে
জমা দিয়ে দিন হ্যাঁ হ্যাঁ
তোমরা সবাই যদি এরকম কথা বলো না তাহলে আমাকে ডাকবে না
এখান থেকে সবাই মুখ খুলতে হয়
তারা পারেন না
একটু আমাদের ফেরত দিতে পারে পিছিয়ে দুটো দিয়ে দিচ্ছি এটা 17 এর এটা 22
দেখছে কোর্ট এখন My lord got the questions there.
24 yes sir we have prepared it by reference also but that small chart sir all the 24 সৈকত ব্যানার্জি রিসিভ করা ওটা 2017 এর ওটা বলি
my lord, I was,
There are the questions of 2 years. One is 2017, one is 2020.
Relates to what?
Both. But there are two matters before your lordship.
4 and 5
Your losses had the item number 5 first. Your losses day before yesterday had the item number 5 first. For your losses in the subsequent take 2022. And so for the 5 year losses take 2027.
2017
2017.
2017, how many?
বলবো হ্যাঁ my lord the one that has been received the Mr. Shoykot Banerjee advocate of the board that is relates to 2017 questions 23 all common everything common all questions common
Shoykot Banerjee ke dis keno bolto?
नहीं बोल
my lord,
Procedure.
my lord, insofar as, my lord, item 4 is concerned, insofar as item 4 is concerned, my lord, that is, my lord, with regard to 2022 TET, my lord, my application, my lord, is in connection with that. I am relying on one judgment, my lord, kindly considers.
Can
My lord, this, my lord, has been, Dada, my lord, this, my lord, has been relied upon, my lord, I understand 2010 volume 6 Supreme Court cases, page 759. Lord, the relevant paragraphs, my lord, I say, my lord, paragraph 14 to 16 and 26. Lord, it is in my lord's brief, my lord. In item number 5, my lord, the copies, my lord, have been handed up to my lord.
দেখো কি judgments কোনো আছে কোনো side করে
I'm sorry, my lord, I did not make, my lord, on the ground, my lord, that my lord possibly.
দেখি
Extent of interference. Revaluation. No rules.
CBSE.
Civil judge. This is 2010 volume 6 Supreme Court cases 759. Revaluation in the absence.
20 and paragraph 20.
Paragraph 14 to 16, 24 and 26. What was the issue? In the absence of any rules for revaluation, whether the writ court can revisit in the facts and circumstances of the aforesaid case.
Why immediate matter.
Paragraph 26, I am heavily relying upon. There are no rules, which vest any power with the primary board, to re-evaluate. If there is no statutory rule, I say that the petitioners, do not have, any fundamental or a constitutional right, to invoke. In any event, for the sake of fairness, the board publish a notification saying that, we invite disputes, if any, with regard to key answers. That date was enlarged by a day or two. The moment that day expires, I say the right, if any, vested with the candidates, it forfeits.
Is to be made perspective of the facts and the questions involved.
Yes, this is with regard to the Public Service Commission, the examination of judicial officers. Even here, there were no rules, to reevaluate. And today, virtually, what the unsuccessful
Decide that what is the evaluation of the other
committee. Kindly sees whether writ court could have done if there are no rules. If the unsuccessful candidates.
how far we can go and extend our thing.
And may kindly also consider the alibi taken by the writ petitioners as to why they did not approach within the scheduled time is because an onerous condition was put in that for each question they are to pay 500 rupees. They virtually are then challenging the rules, So unsuccessful candidates now turn around and challenge the rules. Will my lord permit that?
Question of challenging the rules.
Kindly, that is the alibi they have taken. Why did not they come?
They are not going suspect. We are looking into a different aspect.
At whose locus, Kindly sees, at whose instance?
Focus in a case of an entry of a fundamental right, uses its secretary.
Fundamental right, I put the question to myself, at whose instance? That's
why I'm saying
they waived their right.
the Bhattacharya will cite more many of such judgments when the locus loses its.
They waived. No, even fundamental right can be waived. They waived their right. They waived their right.
Can be there. One we wanted to give it from because it is limiting the different subjects.
That's why it is better to send to an academic institution of repute so that they can then your lordship may appoint as your lordship decides.
That for everything there should be a separate.
আমরা কোন নাম বলবো না Like, we cannot give any name. I should not give any name. But giving name would not create any trouble. Therefore, I'm not going to give any name and leave it to
We
board.
wanted that it should be done in a subject wise.
Very well.
If
That's
it is
no
a case of a physics, then at least the physics. The
My lord will
committee will
appoint
evaluate
someone
the
with a
physics. If it
subject
is
wise.
chemistry, then it will
Yes, yes.
evaluate the chemistry.
Kindly do that. I have no difficulty.
So we have to weed out that what are the subjects.
Lord, we can. I just give one was Bengali.
Child development pedagogy,
Lord, child development pedagogy, which was troubling my lord. That is a very specialized subject.
environmental science,
Environmental science.
I have reservations on that.
My lord.
I have reservations on that.
Yes. Therefore, Lord, we do not.
Contention is not acceptable, at least to me.
Anyway, Lordship will.
Not an expert.
My lord will refer to the expert to this field. Mathematics, Bengali, environmental science, child pedagogy, and 3. Right?
English,
And English. 4.
What five?
5 subjects.
One.
Maths, English, Bengali. হ্যাঁ ম্যাথস আছে তো
ডিসপিউটেড কোশ্চেনের মধ্যে কোন কোন সাবজেক্ট আছে?
ম্যাথসও আছে সার্কামফারেন্স এটা তো ওর মধ্যেই আছে
বললাম তো ম্যাথস বললাম।
What are you talking? Language 1, language 2. What does it mean?
The subject is below English, mathematics,
Oh. What is language 1?
English,
Language 2?
Bengali.
CDP, mathematics, EBS.
দশটা দেখে নেবেন ওরা।
Milord, kindly, Milord, permit me to make one last submission. Milord, whatever, I'm so sorry.
CAV.
Only one last submission.
CAV.
Only last.
I know if I start dictating, then everybody will come and making submissions.
No, Milord,
It is
kindly
better-
confine.
it is better.
Kindly confine.
I'm just keeping it for.
Expert committee.
Milord, kindly confine this only in respect of the petitioners.
না না ওই কমিটি
এটা কোর্টে
Yeah.
পাঠিয়ে দিচ্ছে।
Yeah, after tomorrow.
সেটাই একটু বলে দেন সার্ভে হয়ে গেছে
কি খবর দিন?
ওখানে
Give the names of
এবার
all
দশটার
those
কথা শোনো,
matters.
যে কোয়েশ্চেন গুলো তোমরা রেকমেন্ড করছো ভুল, সেগুলো এক্সপার্টদের কাছে পাঠাবে।
Milord, kindly confine this only, Milord, to the writ petitioners. Milord, that is my last prayer.
কনসিডার তারপরে যারা ওরাও বড় বোর্ডের ভিউ
I don't think so.
Don't listen to the junior.
No, I follow, but I don't think so it can be done.
Very confusing.
Sleeper.
Deceptive.
যা বলা বলা হয়।
Deceptive in appearances, deceptive in facial expression. Very
They had desire that the experts may have their views also into consideration.
No.
I say that is not possible.
No, not at all.
Very well.
We will record. We will not take into consideration.
My lord, but record, like they
We
will
will record that.
they will
not
take it independently
Absolutely independent view.
on the basis of the
No.
books which are taught at that level.
Whatever is there, they are the best person, they will do it. Independent of anything.
Yes, keeping the standard in mind. That's all.
Whatever, they will do it.
Now, unless Lordship says standard in mind, they might think that this is this IAS exam.
I will say will not take into consideration any other thing.
No, they will not. But they will have to consider
Record.
in the perspective of the
The independent.
কাউন্টারি নেবে না, ইন্ডিপেন্ডেন্টলি বলছে তো।
My lord will decide my appeal also, Milord, by item 43. I have given.
We are just constituting, having that particular report to come. Thereafter, we'll see to what can be done.
Milord, the leave to appeal, Milord, may be allowed so that I can,
It will remain, it will consider it.
I get an opportunity to come back before my lord. If my leave to appeal is allowed.
Everything is kept pending. নোট করে নাও, লিখে দেবো যখন অর্ডারটা যখন করবো।
ওটা তো আর লাগবে না।
But may we take back the bunch which has been handed to your lordship?
We are keeping it for a day.
And it
একসঙ্গে সেই বিচারে করে দিই।
হ্যাঁ, item গুলো বলে দাও।
No, no, just give all the item numbers.
Yes, it's all same issue. item গুলো দিয়ে দাও।
কোডটা হচ্ছে 2000
দিয়ে দাও, লিখে দাও item number পরে কোন বছর এগুলো লিখে দাও।
কোডটা 2014 ছিল, আইটা হলো 2017
আর 40 সহজ ব্যাপার
43
লিখে দাও কোন করে ব্যাপার
লিখে দিচ্ছি। এই লিখে দিচ্ছি। আমরা লিখি আইটেম 4 টেট 2022 আর আইটেম 5 হলো টেট 2017। না না আরেকটা বলে দিলাম, ওটা লিখে দিন। আর 43 দাদা
before start of bidding in the auction in which they want to participate, Railway shall verify the audited balance sheet and profit and loss account statement uploaded in the profile in IRAPS of the successful contractor anytime after acceptance of the bid or during the currency of the contract. And if the information about the financial eligibility is found to be false, misleading, or the documents uploaded by the firm are found to be false, invalid. Not I am relying on the invalid, not there is an invalid. Then the allotment of lot shall be cancelled, or if the contract has been issued, the same shall be terminated for treating the security deposit without any further delay. And we are lost to kindness. That is page 42, my lord, qualification notice, my lord. Lord P3, my lord, that is the letter, include letter 6 September 23, my lord. Reference above, you have participated in the auction. Lord, you got it, page 42, P3, my lord. Dated 17th August 23 for leasing of FSLR for 7 days a week and so on. So during participation of the aforesaid e-auction, you have mentioned annual turnover of your company amounting to be 64,32,000 odd. But you did not upload any documents in support of the above claim. In the subject e-auction, the eligibility criteria has been mentioned there specifically in para 2.2 of the standard condition of contract as under. That is the same manner. The entity shall be required to upload an audited balance sheet and profit and loss account of the previous financial year in their profile in IRAPS before started of auction in which they desire to participate. Railway reserve the right to verify the balance sheet and profit and loss account uploaded in IRAPS profile of the successful bidder at any time during the currency of the contract. And if any information about annual turnover is found to be false, misleading, or the documents uploaded by the firm are found to be false, invalid, then the railway may take appropriate punitive action against the entity, including but not limited to termination of the award, running contract along with the forfeiture of the security deposit or cancellation of allotted lot with forfeiture of earnest money without any further notice. In compliance to the above provision, the participating entity is required to upload the profit and loss account statement in support of their annual business turnover positively, but you have failed to upload a valid document, namely profit and loss account, which tantamount to negligence in bidding procedure. As the only eligibility criteria is not supported by proper documents, the competent railway authority, finding no other option, has decided to cancel your bid in the e-auction and to forfeit the amount of earnest money as per 2.2 of the standard condition as well. Lord, they challenge that order, my lord, by way of writ petition, my lord. And my lordship kindly see page 55, my lord. What is the eligibility, my lord? The minimum annual financial turnover in any one of the first preceding 3 financial year of the entity for participation in the e-auction shall be as follows. Up to 40 lakh nil, above 40 lakhs, 20 lakhs, and above 1 crore, 50 lakhs. Not they come last for above 1 crore, not 50 lakhs, but they have.
Which page?
Page 55.
Policy for commercial. Policy for commercial.
এটা পেজ 55 কোথায়? মানে পেজিনেশন ঠিক নেই ম্যাডাম।
আপনি পলিসিতে চলে যান না, পলিসিতে।
There is a page 55. It's your page. Review 34. Huh?
আচ্ছা, আপনি ঠিক লাস্টে আসবেন। 144.
And my lord, lordship kindly see that they have submitted only balance sheet, my lord, page 144, my lord. Last portion, my lord, they turnover that is 23,64,018, but they have not produced the provision loss account.
And the minimum criteria was.
And minimum criteria, my lord, is 50 lakhs. Even, my lord, as per freight marketing circular, my lord, if any punitive action against that action, there is the provision for appeal before the appellate authority, my lord. But my friend, without going into the appellate forum, will not file the writ petition.
কি বলছেন?
Appeal.
2.2.
Lordship kindly is the freight marketing circular, clause 25, my lord, appeal against punitive action of EMD/SD for
What?
termination of
Page?
contract. Page, my lord,
Page 30.
page 38, running page 53, my lord,
38.
38, my lord. Running page 50, freight marketing circular number 11 of 22, clause 25, my lord, appeal against
38 does not have that. That's why I'm.
The absolute
53.
pagination is not telling at all with their pagination.
53, my lord. Page 53.
There are two paginations are appearing.
It's a blackened one or a, which is now again given in a blue ink. Which one is you are reading?
This is the black and one.
Black and white.
Black and,
Blackened one,
Yes, my lord.
page 35.
yes.
Page
This
35.
is a freight marketing circular number 11.
Yes, my lord. Clause 25, my lord.
Yes.
I got it.
Clause?
25.
Yes.
25, my lord, appeal against punitive action of EMD/SD for future termination of contract on any ground. In the case of forfeiture of EMD and or termination of the contract as per any of the terms and conditions of the auction contract agreement or otherwise, the contractor, it desires, may prefer an appeal to the DRM or contractor finalized by division or consider a PHOD for the contract finalized by the headquarters within 30 days of the action of forfeiture of
Without
termination.
availing the opportunity.
But there is
to
a provision for appeal
approach the writ.
before the appellate authority. my lord.
You are so energetic. I have seen in the last matter also you jump. You will get your opportunity. Have patience to listen the other side. Please inculcate this habit of listening. Yes, sir.
My lord, last lordship kindly see the balance sheet. I have already shown the balance sheet. my lord. Last page of
That
the
you have shown 23 lakhs and not.
yes. That is the balance sheet, my lord. They have not produced any profit and loss account, my lord. And my lord, lordship kindly see my 2 or 3 grounds, my lord. My lord, ground number 3, my lord. The language adding lot by not holding that the whole purpose of such a clause is to see that only genuine bids are received, and such purpose would be lost if forfeiture was not permitted. And my lord, next ground, my lord, for that suffering any loss or damages in connection with the misstatement and or false representation made by the writ petitioner is immaterial and irrelevant, inasmuch as the railway authority have a specific right under the tender document to forfeit the earnest money in cases of the tenderer making any false or misleading statement.
That you have quoted, sir.
Yes,
You
yes,
have
but this
quoted
is the law.
1.2. You say that this is what
Yes,
is.
yes, yes, my lord.
Then
I told you.
ব্যালেন্স শিটে যদি কোনোটাতেও যদি 50 lakhs থাকে
Not
accepted.
For the sake of argument, but if the balance sheet is 50 lakhs, then we have no, if they shown in that balance sheet is a 50 lakhs, but I have no objection, he submitted that correctly. But not,
Not even
but not even so, blood, he should file the profit and loss account. Then, but they have not filed the profit and loss account. But what is the reasons behind it, I do not know. Why they have not filed the profit and loss account? Which I didn't agree, huh? Blood, is 90. But before the trial court, my lord, we have filed the report on behalf of the affidavit, my lord, in pursuance of his lordship's direction, my lord, page 99, my lord. The, actually, the relevant paragraph, my lord, para 3, that e-auction for 3.9 ton space of FSLR of Mithila Express to Rockshall was uploaded at IREPS site, of which e-auction was scheduled on 17th August 2023 and commencement date of contract period was scheduled on 29th October 23. That as per the standard condition of contract for contracts awarded through the e-auction, which is the guiding policy of all e-auctioners for commercial earning, no revenue or another earning leasing contract awarded through a e-auction, all prospective bidder will be required to get themselves registered in the IREPS, that is Indian Railway Recruitment System. That bidders intending to participate in the e-auction should register themselves in IREPS e-auction leasing model and participate in e-auction by submitting their bids on so and so on the auction date and time. That white clause 1.4 of the standard condition of contract, it is stated that the same below the entity shall be required, that is the forfeiture clause. Second পড়া যাবে Then paragraph 7 below. The white clause 3.2 of the standard condition of contract, it is stated that the intending bidders are advised to carefully study the scope and associated condition mentioned in the auction catalogue. Any submission of bids by the bidder shall be deemed to have been done after a careful study and examination of auction catalogue with full understanding of the implications thereof. All terms and conditions shall be deemed to have been accepted upon submission of bid by any builder. Then, my lordship, I am relying on paragraph 11, my lord. That during the scrutiny of bid of highest bidder, Messrs. Anjali Shivam Cargo, by the auction conducting officer, it was revealed that the turnover for the financial year 2020-21 as declared by the bidder in the column turnover data entered by the bidder of the bid sheet was 64,32,450, but supporting documents uploaded by the bidder was 23,64,018, which is contradictory and not complying the turnover requirement for the specific bid in auction model, which was 50 lakhs. As such, the bid was disqualified as the only eligibility criteria is not supported by proper documents. That in such situation, the model takers of the declaration of late declaration by the bidder, false declaration by the bidder, and accordingly forfeit the earnest money. My next paragraph, now, the turnover details can be modified by the bidder time to time, but the modified details submitted by the bidder shall have retrospective effect, prospective effect, that is after the future, not only and not the lot for which bid has already been submitted. But this is the affidavit in compliance of His Lordship's, Lord, I have filed that compliance report. And my Lordship, I am relying to judgment. Lord, first judgment, my Lord. And Supreme Court judgment, Lordship. Satish Bhatta versus Sudhi Rawal. Lord, paragraph, my Lord.
Do you have the equivalent citation here? Equivalent citation?
My Lord, citation, my Lord. No citation, my Lord.
We do not know about this with software. First time I'm looking at it. What is this VD software? Madam, it is licensed to you. What is this software?
This is actually a jurist. It's a law library, my lord. Somebody has downloaded sources. But it's authorized and licensed.
Free for all.
At the time of hearing, I do use this. No problem.
Yes, which paragraph you are?
Paragraph 14, my Lord.
14.
14, my Lord, there is another judgment of the Supreme Court quoted. The questions there is whether the respondent are entitled to forfeit the entire amount. It is seen that a specific covenant under the contract was that respondent are entitled to forfeit the money paid under the contract. So when the contract fell through by the default committed by the appellant as part of the contract, they are entitled to forfeit the entire amount. Not His Lordship, relying on another judgment, 1996 four Supreme Court cases, the questions that come up for consideration before this court, paragraph 15, Lord, was where a land is allotted. The allotee deposited some installment, but thereafter intimated the authority about his incapacity to pay up the balance installment and requested for refund of the money paid. Was the allotting authority entitled to forfeit the earnest money deposited by the allotee, or could be only entitled to forfeit 10% of the total amount of deposit by allotee till the request is made? Following the judgment of the Hanuman Cotton Mills, this court held that the allotee have accepted the allotment and having made some payment on installment basis, then made a request to surrender the land, has committed default on his part, and therefore the competent authority will be fully justified in forfeiting the earnest money. And well, next paragraph. Now, this court again in 2004 3 SCC dealt with a case of sale of immovable property. It was a case where the plaintiff appellant had entered into an agreement with the respondent defendant on 15th May 94 to sell the landed property owned by the respondent, and a sum of so was paid by the appellant as deposit or earnest money on the execution of the agreement. In that case, this court examined the nature and character of the earnest money deposit and took the view that the words used in the agreement alone would not be determinative of the character of the earnest money, but really the intention of the parties and surrounding circumstances. The court held that the earnest money serves two purposes of being part payment of the purchase money and security for the performance of the contract by the party concerned. In that case, on facts, after interpreting the various clauses of the agreement, the court held as under. Coming to the facts of the case, it is saying that from the agreement it is so and so, entered into between the parties, particularly clause 1, which specify more than one enumerated categories of payment to be made by the purchaser in a manner and at stage indicated therein as consideration for the ultimate sale to be made and completed. The further fact that sum of rupees 38 lakhs had to be paid on the date of execution of the agreement itself, with the other remaining categories of sums being stipulated for payment of different and subsequent stages, as well as execution of the sale deed by the vendors taken together with the content of the stipulation made in clause 2.
Bottom line of the judgment is that if he has committed any default and the contract provides for forfeiture, then the forfeiture can be done, then no interference is.
Then the lordship, paragraph 70, lordship kindly comes.
This is what a sum and substance of the entire judgment. I have read the whole. I am a fast reader and
Yes. Then lordship kindly see paragraph 70, law is therefore clear that to justify the forfeiture of the advance money being part of advance money.
that is what I say. The terms of the contract must be clear.
Lordship.
If the contract provides, then there is
Yes,
no
yes,
difficulty.
yes. Another judgment is our High Court, my lord.
After Supreme Court, our High Court judgment. High Court has said something differently.
No, my lord. But it's, in spite of lordship kindly see that. That is. That's page 14, my lord. Which I have.
Yes. Now this time the different portal is used. Yes. Anyhow, which paragraph?
Not page, third paragraph 29.
Page.
Page,
At the bottom page is
page
there.
13, my lord.
1-3.
1-3.
Yes.
Paragraph 29 and paragraph 30. That is the 3 paragraphs. And what? It is degree, na? Paragraph 20. Judgment है तो
Yes, that's all.
But another judgment will not.
Another judgment.
But then not only will this Allahabad judgment will not, only will not I am relying one paragraph will not, paragraph 11. Paragraph 28 will not, page 12 will not, I am
27 and 20.
The petitioner, knowing the facts that it was not qualified to participate in the tender, tried to guard the tender by giving a false declaration by oath or affidavit, by misrepresenting the petitioner, tried to get it technically qualified, and accordingly the deed was opened. But in this our case, my lord, the bid petitioner is knowing fully aware of the circular, my lord. In spite of that, my lord, he didn't produce the provisional loss account and not showing the exact balance sheet and exact
Below the limit. Which
Lordship kindly consider paragraph 28. No, this is my
Thank you. Come and argue at 2.
একটা জাজমেন্ট দিচ্ছেন না।
একটাই তো দিয়েছে,
দুটো জাজমেন্ট
একটা দিয়েছে,
আরেকটা কোনটা দেয়নি?
আর যেগুলো সাইড করলেন সেগুলো তো
না, না, check করে দিয়েছে। আর
এই তো
সেমটা দিয়ে
ঠিক আছে।
এটা কত নম্বর প্যারাগ্রাফ সাইট